Rule 3.2 says the tribunal may now vary or waive any of the rules. So one might say, why do we have the rules in the first place? And from our perspective, there are the rules, and if the LAT wants to vary those rules, we may have to advocate a lot stronger for our respective clients to make sure that the rules, as they apply to our clients, should be implemented as opposed to whatever the tribunal may want to vary or change.
And I'll speak a bit about the different categories of evidence you want to think about and some of the different considerations you want to give each of those categories. But even before you get into that exercise, you should stop and think about Rule 49 offers. Those have been referred to this morning. And the thing about trial prep is it is the most expensive period. That is the beginning of the most expensive period for most cases.
Ideally, counsel should show up with an agreement on costs of an appeal, or you always have to show up, if you don't have an agreement on costs, with a bill of costs, and you should have served and filed that bill of costs in advance. Even when we reserve our decision, we still will take submissions on costs at the end. And people who aren't in our court very often will often just look at us blankly when we ask them, well, what about costs? Is there an agreement on costs? That's very different from a lot of the hearings that you attend other than in the Court of Appeal. We don't spend a lot of time on costs, but make sure that you read the practice direction, paragraph 18.